Good evening, everybody, and welcome to our legal forum. Tonight's forum is part of the Orange County Clerk of Court's Legal Matters Forum series, and this evening's topic is on public records. So took us a couple minutes there just to get connected, as we are also carrying this live on our Facebook page. So now we have everything connected. I want to welcome you. I'm Dane Weister, the Communications Director for the Orange County Clerk of Courts. And again, thank you for joining us. We hope you find the information provided tonight during this free legal forum informative and useful. Now, you're going to be able to type your questions, any questions you might have, into the Q&A chat that you'll see at the bottom of your screen. And we'll have a Q&A segment where we'll answer your questions towards the end of the webinar and those questions you've submitted. Another thing is we ask you to fill out a survey at the end of our presentation so we know some of the topics you'd like to see in the future, and helps us to know how we're doing here and how this information was useful to you. This webinar again is being recorded and will be posted to the Clerk of Court's social media channels and to our website. So without further ado, let me introduce you now to our Orange County Clerk of Courts, Tiffany Moore Russell. Tiffany.
Thank you, Dane, and hello, everyone, and thank you for joining us this evening for our legal forum on public records. This is the chance for you to know exactly what type of documents you have the right to obtain and how to go about requesting or viewing them. I personally created these free legal forums called Legal Matters as a service for the community to make legal and court information more easily accessible. These forums are one of the best ways to provide our citizens access to justice and access to the important information you all have the right to know. All forums are always free to attend, and holding these legal forums virtually has created new opportunities for us to bring them to you much easier. Now, I want to take the time to acknowledge my staff who have worked hard to bring this webinar to fruition, as well as acknowledge our panelists who are here today. So allow me to thank Dane, Leon, and Charlene, and all involved to make sure this is a successful event. And presenting this evening from my office, we have General Counsel Roberta Walton Johnson. From the Orange County Comptroller's Office, we have Senior Official Records Coordinator Christy Willis. And to round out our presenters, we have Executive Director Camilla Perry with the State Attorney's Office. Thank you all so much for taking time to share your valuable insights with our community. Now, let's kick this off. Tonight, we are going to give you an overview on all kinds of records. We have public records, court records, official records of Orange County, and how to go about sealing and expunging records in a court case. Now, at my office, we have public records and court records, and I want to give you a quick overview on the difference. A public record is any document, paper or electronic, made or received in connection with official clerk business, such as papers, letters, notes, emails, and correspondence. Public records in Florida are governed by Florida Statute Chapter 119, which is known as the Government in the Sunshine Law. Now, court records are different. They are governed by the rules of judicial administration, which is overseen by the Florida Supreme Court. Most court records are open to the public once sensitive or personal protected information is redacted. And you can then view those public court records or documents online by visiting my website at myorangeclerk.com. With more details on all of this, I now want to turn it over to my General Counsel, Roberta Walton Johnson, who will give you an in-depth look at the records at the clerk's office. Roberta, you have it.
Thank you so much, Clerk Russell. Good evening. As Clerk Russell shared, my name is Roberta Walton Johnson, and tonight I'm going to share with you from a procedural standpoint, how to request public records from the Orange County Clerk of Courts. Next slide, please. Before we get into the procedural steps, I would like to give you just a brief overview as it relates to the public records law. Florida begins its tradition of openness way back in 1909, several years ago, with the passage of Chapter 119 of the Florida statutes, which we call the Public Records Act. This law provides that any records made or received by any public agency, that's going to be very important as we proceed, in the course of its official business, are available for inspection unless specifically exempted by the Florida legislature. Next slide. Now, our Florida Constitution really establishes that every person, and that does mean everyone, every person has the right to inspect or copy any public record. This section specifically includes the legislative, executive, and the judicial branches of government, which includes the counties, the municipalities, the special districts, and each constitutional officer, board, and commission. Now, while the Florida Constitution really has directed it towards all three branches of government, please note each branch has different laws and/or rules that regulate access to its records. Next slide. Let's start with the executive. The executive branch of government really means and refers to any state, county, district, authority, or municipal officer, department, division, board, bureau, commission, or other separate unit of government created or established by Florida law. This applies only to the executive branch agencies and their officers, and to all local governmental entities and their officers, which do not include the legislature or the judiciary. So again, Chapter 119 includes the executive branch agencies, all that I've described, but it does not, it segregates the the Florida legislature and the judiciary. The legislative is subject to every person, spells out that every person has the right to inspect and copy records of the Senate and the House of Representatives received in connection with the official business of the Florida legislature as provided by the Constitution of this state. Section 11.0431 of the Florida statutes codifies what the rules are as it relates to the records of our Florida legislature. The judicial. Now, the judicial branch is codified under the rules of court, which are established and adopted by the Florida Supreme Court. Rule 2.420 of the Florida Rules of General Practice and Judicial Administration state, the public shall have access to all records of the judicial branch of government except as provided below. The judicial branch includes the state court system, the clerk of court when acting as an arm of the court, the Florida Bar and the bar examiners, and the Judicial Qualifications Commission. It includes all other entities established by and/or operating under the authority of the Florida Supreme Court or the Chief Justice. Next slide. Now, keep in mind, we talked about defining a public record. A public record is really defined as anything that is made or received pursuant to law or in connection with the transaction of official business of an agency. Now, I'm not sure I bolded that because it's very important. You can create a record, but it needs to be in connection with the transaction of official business for it to be considered a public record. And, not or, but and intended to perpetuate, communicate, or otherwise formalize knowledge. Anytime you share a document, a record, to otherwise formalize knowledge and/or which means effectively, you're sharing information with another source. You are creating what we call a public record. Next slide. Now, defining a judicial record, because there is a distinction between a judicial record and a public record. A public record is subject to Chapter 119. A judicial record is subject to the rules of court, specifically Rule 2.420 of the Florida Rules of General Practice in Judicial Administration. And it's defined as anything that is made or received in connection with the transaction of official business by any judicial branch entity. Now, that includes both court records and administrative records of the judicial branch. Court records are inclusive of all contents of your court file. It includes the progress docket and other similar records generated to document or support the activity of a case. Administrative judicial records are all other records made or received pursuant to court rule, law, or ordinance by a member of the judicial branch of government, both still subject to the same rule. Next. Now let's get down to how the clerk of courts plays a part in all of this. The clerks are required to provide public records in two separate capacities: as a court records custodian and as an agency subject to the public records law under Chapter 119. The clerk of courts are both a government agency subject to Chapter 119, but also a member of the judicial branch when operating specific to the judicial branch and subject to the rule of 2.420. Next slide. Court records. So when the clerk is acting in his or her own, in the capacity as part of the judicial branch of government, as I said previously, access to judicial records under the clerk's control can only be garnered exclusive to Rule 2.420 and not Chapter 119. Next slide. Now, we talked about there being some exceptions earlier. In one of the slides we already discussed previously, I said with the exception of. I didn't tell you what those exceptions are because I knew that we were coming forward to talk about specific statutory exemptions as it relates to court records. And they are specific to different areas of the law. When it comes to domestic, we have family services for children. Those records are exempt. We have domestic violence, the victim's information as it relates to domestic violence cases, and any information related to child abuse and sexual offenses. All of that information is considered confidential and exempt and cannot be shared with the general public. We have, in the criminal area, pre-sentence investigation reports, grand jury records, sealed criminal histories, and information relating to victims of human trafficking. As it relates to some of our financial case types, like guardianships and probate cases, all estates and inventories, all estate inventories and accountings from guardianship cases, Social Security numbers from all cases, bank account information, charge or debit card information, and credit card numbers, and both birth and certain information from death records are all considered confidential documents and information and cannot be shared with the general public. We have Baker Act records, substance abuse records, behavioral health evaluations, and anything related to drug court reports from someone being treated from a clinical perspective, any of that information is also not subject to disclosure. HIV, STD records, any information related to tuberculosis diagnosis, juvenile delinquency and dependency records, adoption files, gestational surrogacy, and anything related to a minor asking for a pregnancy termination and filing for the right to do it on her own account is also not subject to disclosure. There are 25 statutory exemptions to the Florida Rule 2.420 that basically are either act as either exempt or confidential information. There is a distinction between exempt and confidential information. Exempt case files means because of a statute or by court order, the entire file is closed and not open for disclosure. Whereas there's also confidential information within a record, that information must be redacted before a record is disclosed to an individual from the general public. Next slide. Here is a list per category from a juvenile case type, family, domestic violence, criminal and traffic case types, civil, probate, and or guardianship and mental health cases that really spell out all 25 of those exemptions. Next. Now, the procedural process. First and foremost, how are records requested from the Orange County Clerk of Court? Records are requested from all different types of avenues, via telephone, in person at one of our counters, via the mail, and or written or electronic means, i.e. our website and or our email. If you are interested in obtaining a record or making a public records request here in person, we ask that you come to room 150 on the first floor of the Orange County Courthouse, and one of our deputy clerks will happily assist you. If you'd like to also go to our website, that is www.myorangeclerk.com, and we have a specific email address where we also entertain public records requests, public.records@myorangeclerk.com. Once we receive the request, we clarify that a written request is not necessary for the public, i.e. under Chapter 119, for all of those requests, it is not necessary for that request to be in writing, nor do you have to have a specific purpose as to why you are asking for it. We also don't require identification. However, if you are requesting a public records request under 2.420, i.e., if you're asking for a court record, that request must be in writing. Once we clarify what type of request it is, whether under Chapter 119 and or under 2.420, we then provide a written estimate of the charge. No, it's not for free. There is a statutory fee that is associated with the request of public records, but it's not much. A written estimate of charges in the form of an invoice is actually sent to everyone who makes a request electronically. If it requires extensive labor and research, there is an additional charge that we are allowed to charge and assess for every records request. However, that request can't be at an alarming rate. It must be at the rate of the smallest, the lowest wage of an individual working in that particular division. i.e., if someone in that division that you're requesting is working on this public records request, and someone makes $20 an hour versus someone who makes $40 an hour, we can only charge you at a rate based upon the time associated with that lowest rate and that lowest wage earner from that particular department. All fees must be paid in full before a records request is processed. Therefore, a written estimate is sent to you in the form of an invoice based upon the fees assessed for the particular request. Then a link is provided for you to be able to pay online and or in person. We accept check, money order, cash, and or credit card. Keep in mind, service charges apply with credit cards and online payments. And then your request is processed. Next. The charges for records request, if you're asking for a court record, that is $1 per page. I.e., if you're asking for a court record, it's $1 per page. If you're asking for an administrative record, whether that administrative record falls under 2.420 or Chapter 119, it is 15 cents per page. Keep in mind, if it is a double-sided copy, it's 20 cents. The service charge, again, I stated to you earlier, it's extensive research or extensive labor. That's the only way we charge an additional surcharge. And what has been defined as extensive is anything that takes 15 minutes or more and utilizes extensive technology and or clerical resources. If you are interested in having your your records transferred to a USB drive, we sell USB drives as well. We offer clerk of court USB drives. They are 4 gigabytes in size, and they are assessed at a flat fee of $7 per drive. Next slide. Again, this gives you a little bit about what is required and what we call extensive for the special service charge. It is 15 minutes to locate, review, redact all the confidential information, copy, and to refile and, pull all of the records that you've requested together. So based upon that, that's how we charge that additional service charge. It's why we charge the additional service charge. Next. Other procedural considerations. Whether or not you can request to access records and that request be in writing, again, that is not what we request under Chapter 119. It is not necessary, but under 2.420, it must be in writing. Whether or not you have to state the reason that you are making the request under neither Rule 2.420 or Chapter 119 is that necessary. We do not ask you why are you making the request. Whether or not you get to determine what format the record comes in. We have people who say, you know what, I only want it in an Excel spreadsheet. Well, if we don't already have that record in an Excel spreadsheet, we don't necessarily have to change it to whatever format you're requesting. As a matter of fact, we do not. We give you the record in whatever format we have it in. If the request is denied, the basis for denial must be put in writing. Absolutely. Both under Rule 2.420 and Chapter 119, If we are denying the request because it is exempt and or confidential under the laws of this state and or the rules of court, we put that in writing and we share with you the reason why we are denying your request. Does the clerk have to answer questions about the record? i.e., if you're asking to access the record, or if you simply want or have questions about the records that we have. We do not answer questions about our records. We would be more than happy if we have the record to provide it for you upon your request. However, we do not go into the record and answer specific questions about the record. Whether or not the requesters must provide both their name and contact information. No, we may ask you for your name and contact information. However, you do not have to provide it to us under either 2.420 or Chapter 119. Therefore, if you prefer to be anonymous, we are open to that. Is there a specific time limit that we have to turn around and respond to your public records request? No. However, we are going to be as prompt as we possibly can. Once we receive your public records request, we acknowledge it immediately, let you know we're working on it, and we respond to all public records requests within a reasonable amount of time. Is there a requirement to create a record that doesn't already exist? I'm sorry, but if we don't already have an existing record on hand here with the Orange County Clerk of Courts, we are not required to create one under either Rule 2.420 or under Section 119. Next slide. The great thing about how far we have advanced as it relates to court records, kudos to Clerk Tiffany Moore Russell and all the clerks throughout the state of Florida, but we now have an online court records case management system for you to be able, to conduct your own search. The My eClerk system here for the Orange County Clerk serves as our online search engine and is located on our website for you to be able to conduct your own individual searches for free of charge. The information contains court documents and information on individual cases here in Orange County, Florida only. Our record searches are limited to the first 500 results. And we ask that you just simply refine your search if you are looking for something specific. The online docket information is available for most cases filed from approximately 1990 to the day in present. Documents are available from 2009 on most case types as well, with the exception of those that are exempt from the general public. Again, to conduct your own online search for a court record is free of charge. So in conclusion, I hope I have provided some information about the procedural requirements of how to request a public record here with the Orange County Clerk of Court. Here is our information one more time if you are interested in requesting a public record. You can request via email, public.records@myorangeclerk.com. You can pick up the phone and contact our records custodian, 407-836-6334. You can also request a public record online at our website, www.myorangeclerk.com, or you can do it via mail. It's our mailing address, or in person in room 150, the Orange County Courthouse. It has certainly been my pleasure to share with you this evening, and I look forward to hearing from each of you soon if you have questions regarding public records requests.
All right, thank you, Roberta.
You're welcome.
So very good presentation. We have a few questions that have come in. So far, most of them, well, a couple of them are asking about sealing of records, and we have that still coming up in a presentation. And also we have a presentation coming up with other official records. So I want to now introduce our next presentation and our speaker. We have Senior Official Records Coordinator, Christy Willis. Now she has details about the types of official records that the Orange County Comptroller's Office maintains. Thank you for joining us, Christy. It's all yours.
Thank you for having me. Good evening. I'm Christy Willis, an Official Records Coordinator with the Orange County Comptroller's Office, and I'm excited to bring this information to you. Our Official Records Office is conveniently located downtown Orlando, just blocks from City Hall and the Orange County Administration Building. You can find us at 109 East Church Street in Suite 300. The building is named Magnolia Place, and it's on the corner of Church Street and Magnolia Avenue. The Orange County Comptroller was granted authority by the Florida Constitution and established in 1972 through a special act of the Florida legislature. Notably, Orange County stands as the only county in Florida where the comptroller is independently elected and distinct from the clerk of court. Florida Statute 28.222 outlines the specific documents permitted for recording in our official records. These include deeds, leases, mortgages, notices of commencement, claims of lien, and other instruments pertinent to the ownership, transfer, or encumbrance of real or personal property. Essentially, our records are primarily comprised of land records and court documents. If you own property in Orange County, your documents are housed within our records. The most frequently recorded documents follow a specific order, and that's deeds, mortgages, satisfactions, notices of commencement, court judgments, and other associated court documents. This chart illustrates a comparison between the volume of documents processed in March for fiscal year 24 and fiscal year 23. Our percentages shown in the far right column have remained relatively stable, with a slight increase of 0.2% in the number of documents processed. All paper documents are scanned as part of our requirement to ensure all records are readily available for viewing, with a few exceptions that we'll discuss later. Additionally, we create an online index for searching, where we input all names associated with each document. The Florida Attorney General has addressed the recorder's ministerial role as it relates to recording and the prescribed authority regarding what instruments may be accepted for recording into the official records. Therefore, if a document is submitted and it meets recording statutory requirements, it is accepted. The majority of documents we handle are received electronically, with our current electronic intake standing at just over 90%, or in March it was 91.07%. Electronic recording, also known as e-recording, stands out as the most efficient method for submitting documents to us. With this option, gone are the concerns about parking, navigating one-way streets, or contending with dedicated bus lanes. With e-recording, you simply scan your document and utilize a vendor application to upload it along with associated data. No special equipment is necessary. All that's required is a computer with high-speed internet access and a scanner. Importantly, your original documents remain securely in your possession. Funds are seamlessly transferred using ACH for recording fees and any applicable taxes on obligation or consideration. A nominal fee is paid to the vendor for facilitating this process. By opting for e-recording, you can track your document as it moves through the process, eliminating any potential for lost documents. Typically, documents processed in this manner are recorded on the same day. Once completed, you can promptly retrieve an image containing our stamp, confirming that it's included in our records. We provide e-recording services through the vendors listed on our website. While we cannot endorse any specific vendor, we do offer direct links to their sites, enabling you to research each one and determine the best fit for your needs. As mentioned earlier, there are several documents that we are not permitted to display on our website in accordance with Florida statute. These include death certificates, military discharges, and specific court documents related to family law, juvenile court, mental health, and probate matters. Additionally, in accordance with Florida Statute Chapter 119, specific protected groups have the right to request redaction of exempt personal information from the public records. The request form is accessible on our website, and these protected groups include law enforcement personnel, code enforcement officers, emergency medical technicians, among others, with new groups added periodically. We redact non-public information from our records upon request as long as the requester meets the qualification for confidentiality, which is established by statute. This modification of the document generally includes home addresses, legal descriptions, parcel identification numbers, and telephone numbers, although the criteria differs based on the protected group. Legislative changes or glitch bills have been enacted to address unintended consequences of these laws. The Comptroller's Office also oversees tax deed sales, which involves the sale of properties due to non-payment of property taxes. This process culminates from a certificate sale conducted by the Tax Collector's Office and is regulated by Chapter 197 of the Florida statutes. In the previous fiscal year, we received a total of 799 certificates for sale. Our main responsibility in this process is sending notices to all interested parties and conducting the auction. This auction is held online, mirroring the format of the foreclosure auctions that are managed by the Clerk of Court. With our diligence and notification, we ended up only taking 67 certificates to sale, representing about a 95% redemption rate. Recording fees. There are fees associated with recording documents in the official records, which can easily be calculated using the fee calculators available on our website. So prior to your visit to our office, delivery by mail, or submission through an e-recording vendor, these calculators can assist in determining the applicable fees. The standard recording fees are $10 for the first page of a document and $8.50 for each additional page. Also, since we generate an index for document retrieval purposes, there's a fee if a document contains more than 4 names. In such cases, $1 is charged for each additional name listed. Certified copies of documents can be requested conveniently through our website or by reaching out to our office directly. Copy fees are $1 per page with an additional $2 charged for certifying the document. We accept credit card payments, but note that there is a limit of $500 per visit on credit card transactions. Once you initiate an official record search on our website, you'll receive this disclaimer. Our index functions similarly to a card catalog from the library, providing a guide to the information contained within our records. After reading and accepting the terms outlined in the disclaimer, simply confirm to the system that you're not a robot to gain access. If these terms are unacceptable, you can always click the back button to exit. For further assistance, our customer service personnel are available to take calls during normal business hours of 7:30 a.m. and 4:30 p.m. Monday through Friday at 407-836-5115. When prompted by the automated menu, select option 5 to speak with a representative. There are two options for searching our database. There's a basic and an advanced search. These options enable users to search based on different criteria, providing flexibility and customization in their search process. In the basic search, users can search by recording date, document number, grantor grantee, or either party. The either party search option proves to be the most effective, as it allows users to search regardless of whether the party they are looking for is the grantor or the grantee of a specific document. Many times this is unknown. So in this context, the grantor refers to the first party or the executing party, while the grantee refers to the second party, or usually the recipient. If they're inundated with too many search results, they can effortlessly switch to the advanced name search, where the wildcard feature can be engaged for more refined results. However, if even greater specificity in a search criteria is required, utilizing the advanced search option may be necessary. Additional criteria for advanced searches includes parcel identification numbers and case numbers. The results from your search will be displayed in a list format. From here, you can sort these results by various criteria, including document number, description, recording date, grantor, grantee, or legal description. You can also sort your results by document type. For instance, if your search returns 24 document types and you wish to filter and view only affidavits, simply click on the affidavit doc type in the list on the left and apply the filter. Additionally, you can print regular copies of the documents by clicking the printer icon. You can preview the document by clicking on View. Otherwise, to switch to presentation mode, print, export, download, or rotate the document, you can utilize the icons located at the top of the image display. Once you've decided to move forward and purchase certified copies from our site, select the document and click the cart icon. You can add multiple documents to the cart for purchase. However, if you require only regular copies, not certified, they can be printed from our site free of charge. Even if you require multiple copies, only one needs to be purchased, as you can print as many as you wish. Alternatively, if you decide to cancel the purchase, simply click the cancel button. It's important to note that we certify only complete documents, so the page range will automatically default to all pages. Once you're ready to complete your purchase, review the items in your shopping cart to ensure the accuracy. And if you wish to remove any items, simply click on the X associated with the entry. Orders received by 4 p.m. will be processed the same day, Monday through Friday, excluding holidays. And upon completing your order, you'll receive a confirmation email detailing the expected costs. And once we process your request, you'll get 2 emails from us, one with your documents and another with the receipt. Please ensure to check your junk or spam folders if you don't receive one of these messages. We also process requests in the order in which they're received. From there, to pay online, start by selecting credit card from the payment method field, then enter your customer information, including your name, email address, and phone number. In the shipping information section, provide all your complete address. Remember, all fields marked with an asterisk must be completed for successful processing. On the billing information screen, ensure that all required fields are completed. This information will be compared to the credit card billing details. Select the type of card you'll be using. We accept Discover, Visa, and MasterCard on this site. Once you confirm that you're not a robot again, the next screen will prompt you to enter your card number and expiration date. It's a very easy process. This concludes the comptroller's portion of this presentation. Thank you for your attention.
Great. Okay. Thank you, Christy. Appreciate that. So We've had a few questions come in, and actually a couple I want to get to right now because it might pertain to the comptroller's office or not. So one of the questions we've had typed in is, are we aware in Orange County of how to assist manufactured homeowners with forms of declaration of homestead and declarations of domicile information for mobile home owners? As an Federation of Mobile Homes, FMO, owners official encourages those who live in a mobile home in a park where they do not own the land, it is on to file both of these to protect themselves in the event of a lien. So I do know, I don't know if, well, I shouldn't try to answer the question. Our panelists, anybody here can share with us where they get those forms. I don't know if any of our agencies, might be property appraiser. Anybody have any insight? Again, these are forms of declaration of homestead and declaration of domicile information for mobile home owners.
Hi, Dean. I would recommend that the customer reach out to the property appraiser's office. I will tell you, if they do not have them here in Orange County, I would recommend you contact an attorney to assist you with that process. The Orange County Clerk of Courts does not have those forms.
We do record declarations of domicile in our records.
Okay. Chrissy, do you know if they are available through your office with the Orange County Comptroller?
Yes, they are.
Okay. Okay. What about homestead? Okay, no, so that would be property appraiser. Okay. All right. Also wanted to clarify, one of the questions was asking about getting a recording of this. Yes, this webinar is being recorded and it will be available immediately on our Facebook page, which is the Orange County Clerk of Courts Facebook page. It'll also be available later in the week on our website. So it is available to view, even on our YouTube page, you'll be able to find it. So it is recorded, and immediately, if you're looking for it right after this to share, say first thing tomorrow, go to our Facebook page for the Orange County Clerk of Courts. So a reminder that you can submit more questions with us. We're going to get to the rest of them after our last presentation here. Several of the questions were related to sealing of records. So we have for our next presentation, Camilla Perry, who is with the State Attorney's Office, and she's the Executive Director and General Counsel at the State Attorney's Office. Camilla Perry, thank you for joining us.
Hi, good evening. Thank you very much. I'm glad to be here. Like Dane said, my name is Camilla Perry. I'm the Executive Director and General Counsel with the State Attorney's Office for Orange and Osceola counties. I'm going to be going over the sealing and expungement process and some quick updates regarding Marcy's Law and Supreme Court opinion that was just released. So to start off, sealing and expungement, in a nutshell, is once a case has been resolved in the trial court and officially disposed of either by a withholding, a dismissal, a no pros, in other words, there's no conviction of guilt, that case becomes potentially eligible for sealing or expungement. In order to be eligible, the criminal offense itself must be eligible for sealing and expungement. And we're going to go over which crimes are eligible and which crimes are not eligible for sealing or expungement. You are eligible for sealing or expungement if you have never been adjudicated guilty of a crime or certain juvenile offenses in your lifetime. You only get one bite at the sealing and expungement apple. You may be eligible if you have not been adjudicated guilty or delinquent for committing any of the acts stemming from your arrest. That is the case that you are trying to get sealed or expunged. If you have never had any other criminal offenses sealed or expunged in your lifetime. You may be eligible if you do not have any other petitions to seal or expunge pending in court. And you may be eligible for sealing and expungement if you are no longer under court supervision. That is, that you paid all your fines and your fees, your probation is finished, and you no longer need the court to supervise you due to your arrest. But what is the difference between sealing and expungement? The sealing is the placement of a criminal record under court order protection, which bars public disclosure of or access to the record. So the information is still physically in a file located with the agency, but the record is confidential, meaning that the record cannot be given out when it is requested by certain individuals or agencies. Now, there are also exceptions to that rule. We'll go over those soon. Expungement is a court-ordered physical destruction of a record by any criminal justice agency that is in possession of the record. That means that the file is physically destroyed. It no longer exists, but one copy of the case will remain with FDLE, which that's the Florida Department of Law Enforcement, for limited purposes. So even though it's expunged, there's still going to exist one physical file with FDLE, but no one else will be able to see that record with certain exceptions. So, under both statutes, sealing and expungement statutes, which is section 943.0585 and 943.059, certain offenses will not be eligible to be sealed or expunged, even if your adjudication was withheld. So you might say, well, if my adjudication was withheld, I wasn't convicted of any crime. So then that means the case was disposed of without a finding of guilt. That's just not true for certain offenses. There are certain ones that are just do not qualify no matter what, even if if you're not convicted technically. However, if the charges were dropped or otherwise dismissed, you still may be eligible for sealing and expungement. But in general, the disqualifying offenses are several: sexual misconduct with a developmentally disabled person, sexual misconduct between an employee and a mentally ill patient, luring or enticing a child, sexual battery, procuring a minor for prostitution, lewd or lascivious offenses committed upon or in the presence of persons less than 16 years of age, voyeurism, any violation of the Florida Communications Fraud Act, lewd or lascivious offenses committed upon or in the presence of an elderly person or disabled person, sexual performance by a child, criminal conduct by public employees and officials. This is this is a long list, but I wanted to go through them all because everyone asked, well, what about mine? What about mine? These are all listed in both of the statutes that I just cited. But another disqualifying offenses is providing obscene materials to minors, computer pornography, traveling to meet a minor, selling or buying of minors, drug trafficking, any violation that's specified as a predicate offense for registration as a sexual predator pursuant to section 775.21. There's still some more. Any offenses that are listed in section 907.041, which includes arson, aggravated assault, aggravated battery, illegal use of explosive, child abuse or aggravated child abuse, abuse of an elderly person or disabled adult, aircraft piracy, kidnapping, homicide, manslaughter, sexual battery, robbery, carjacking, lewd, lascivious, and indecent assault upon or in the presence of a child under 16, sexual activity with a child who is 12 years of age or older but less than 18, burglary of a dwelling, stalking and aggravated stalking. There is more. Any act of domestic violence. Now that's a broad one because, domestic violence is a pretty common case, but if you have an act of domestic violence, including assault, aggravated assault, kidnapping, false imprisonment, anything related to a domestic violence that falls under section 741 of Florida statutes will disqualify you from having your case sealed or expunged. Home invasion, robbery, any act of terrorism, manufacturing drugs, or attempting or conspiring to commit any of these crimes. So you say, well, I don't know what other crimes are left. What else could I can possibly commit that can be expunged? Well, there are a lot. Minor offenses that don't involve victims, things of that sort. So I said before that you can only expunge one record at a time. I did want everyone to be aware of the directly related rule. And it does allow a court in its sole discretion to order the sealing of a criminal history record pertaining to more than one arrest if the arrests directly relate to each other. So if you have a situation where you're if you're arrested and there's two offenses that kind of derive from the same episode and they're really, really closely related and they can't be separated, the court can expunge both of the records, because the spirit of the law is to, you know, do away with the record one time. So, you know, what's the point of doing away with one if another one still exists that's really closely related to the other one? So the court will allow that in their discretion. What is the process for sealing or expunging a record? So the process is virtually the same with two exceptions. For an expungement, you must submit an application to be reviewed and signed first by a prosecutor with the state attorney's office in the sealing and expungement unit before you send it to FDLE. I'm going to go over the steps, each step in the next slide, but this is important to remember. If you want to expunge a record, you have to have it reviewed first by the state attorney's office. And secondly, your record must be sealed for 10 years before it can even be expunged. So you have to seal your record first, wait 10 years, and then you can apply for an expungement. I don't know if this, I'm sorry. I need to go back. I don't know if this screen, and I'm sure it's hard to see, but up in the top left-hand corner, there's a QVC code that you can scan with your phone, and you can bring this up, and hopefully you can take it, print it, make it larger to view. But we wanted to condense all of these steps for sealing and expungement in one document. It is a very confusing, and it can be confusing just reading the statutes if you're reading it by yourself. If you don't have the means to afford an attorney, and you want to do it yourself, you absolutely can. So here are the steps you should take. First of all, you have to fill out an application that's provided by FDLE. You can either download the application directly from our website or from FDLE's website. You have to remember that when you get the application, you have to do 3 things in order to complete the application. The first thing is to get your fingerprints done by your local law enforcement agency. The state attorney's office does not do fingerprints. You have to go to a law enforcement agency. They'll give you a fingerprint card, and they'll have you put your fingerprints on the card, and they'll give you the card to take with you. The second thing you do is get copies of your certified disposition from your clerk of court's office. I think, well, let me not say that. That's the question I might need to ask at the end. How exactly do you get your certified disposition from the clerk's office? But I know you can go to the clerk's office and they'll give it to you if you ask nicely. And then you must prepare a money order for $75. And that is important because they will not process your application without the cash. So you want those 3 things in hand when you get the application. Downloading the application is the easy part. Once you get the application downloaded and you have these 3 things with it, then you can mail the application to FDLE. Now remember, if you want to expunge a record, you do those 3 things, but you send the application and those 3 documents, or the 2 documents, to the state attorney's office for review. Because the state attorney's office takes that application and we have to fill out what's called Part B. We'll send that back to you. And once that's filled out and returned to you, then you send it to FDLE. Once you have completed all the steps, you'll receive your certificate of eligibility from the FDLE. You must keep all of your original documents. So make sure that you're sending the originals and you're getting the originals back. I would still keep copies. I would get 2 certified copies of everything. You know, that's, if you want to keep, you want to make sure that you're not going to be missing anything or nothing is lost. Once you get your certificate of eligibility, then you can file your petition with the state attorney's office. That is something you can also download from our website. It's a fillable document. You fill out the form. You have to have an affidavit that goes along with that. That needs to be notarized. You can get that notarized at your local MSCOT. The clerk may or may not. I don't think the clerk is doing that now. But you can get it done at a bank. You can get it done by, a friend that's a notary. And also a proposed order. All of these documents are included with the petition that you can download from our website. You would take that and you will file it with the clerk's office. Once you file it with the clerk's office, that will be sent to our office for review. And I forgot to mention that you can mail it to the clerk's office or you can drop it off in person. And there's a $42 fee for that. That must also be submitted by money order. Once the petition is filed, that goes to the judge, and the judge will review the documents for approval. If the judge approves it, he reviews it, he signs the order. He sends the order to the respective agencies, and the order is filed with the clerk, and your record is sealed. There are some instances where the state attorney's office may object to sealing your record, and we're going to talk about that next. So if you were arrested and you took a plea, and assuming that it was one of the excuse me, criminal matters that can be expunged, and you specifically included a no seal or expungement condition in your plea, then the state attorney will object, obviously, to your record being sealed or expunged later on down the line, because you've already agreed that that's not going to be something you'll do in order to take this plea. If you were a public official, including a judge, the state may object. If you were a law enforcement officer, sworn or unsworn, if you're a lawyer, if you breached a public trust, if you breached a private trust, such as a fiduciary relationship, maybe with a guardianship or in a probate matter, if you committed theft from your employer, the state attorney may object. If you committed a crime against a minor, an elderly, helpless, or mentally or physically disabled person, the state attorney may object. The state attorney may object to a crime involving I'm sorry, did I mute myself? Okay, sorry.
Yes.
The state attorney may object if you committed a crime of moderation, that you took, if you were a sleuth and took a lot of time to plan it out, and you had time to reflect and change your mind on doing the right thing. The state attorney may object. I don't know, my screen is not moving forward now. Roberta and Christy have perfect presentations, no hiccups, and I don't know what I did wrong. Okay. The state attorney may object if you use a minor, an elderly person, or a helpless person to help you commit your crime. They may object if you committed a misdemeanor of voyeurism or indecent exposure. They may object if you committed an act of violence against an animal. They may object if you have an extensive prior history of court withholds, but no prior adjudications, obviously. And the catch-all is the state attorney's office may object if you committed any crime that seems otherwise morally reprehensible. So if it's just something that just doesn't sit right with a prosecutor, and they think it's not right for the public not to be made aware of your criminal history, the office may object. Even if you get your record sealed or expunged, you still must make a truthful disclosure of your record if you are a candidate for employment with law enforcement, or if you are a defendant in a criminal prosecution, or if you're seeking admission to the Florida bar. And there's a theme here. All of these positions require public trust. So even if you get your record sealed or expunged, you're still required to tell certain people that you have a criminal history. If you're seeking employment, licensing, or contracting with the Department of Children and Family Services, or the Agency for Healthcare Administration, the Department of Juvenile Justice, similar agencies, you must disclose your record. If you're seeking to be employed by the Department of Education or any district school board, university, laboratory school, charter school, any school, essentially you have to disclose. If you're attempting to purchase a firearm, actually, I have to double check that. I'm not sure if the change in the constitutional carry law has impacted this disclosure, but I'm not sure. And if you're seeking authorization from a Florida seaport, or if you're seeking to be appointed as a guardian. All of these things are exceptions to the rule that these agencies will still be able to learn of your sealing. And if it's been expunged, you still must disclose it under the law. Any questions on sealing and expungement? I don't know, Dane, if I'm stealing your thunder, do you want me to keep moving forward, or were there any questions?
Okay, well, there were a couple different questions on sealing and expungement. So if you want to get to that now before we move on to Marcy's law, we can do that.
Sure.
Okay. All right, okay, so one of the first questions related to this was, what is the process for automatic sealing of criminal history record under section 943.0595? I don't know if.
The only mechanism I know for automatic sealing and expungement is a juvenile record. And that it depends on what the record is, and it'll be automatically expunged by age 21 or 26, and there are a lot of factors that go into that. There are other expunctions that are not automatic, but there are different reasons for an expunction to happen. For example, there's administrative expunctions that can be kind of, I guess you'd say, automatically imposed by maybe a law enforcement agency who admits that your arrest was done wrongfully. They may move for an administrative expunction or sealing of your record, things of that nature. But everything else, other than juvenile records, on some level has to be applied for, and it's not automatic.
Just really quickly, Kamila, and in response to this, there was a recent piece of legislation which passed last July of 2023, which affects the automatic sealing. Certain cases actually fall up under the auspice of section 943.0595. Who will make that determination is FDLE, and FDLE basically compiles a report and sends all eligible applicants to each clerk's office throughout the state of Florida. And once we receive that information, then yes, we will make that information confidential and seal it.
Okay, thank you.
And so I would say to a customer who might be interested, to find out, read the legislation, read the statute, find out if they meet the criteria, and then reach out to the FDLE.
Okay, great. So next question related to sealing and expunging records. Can battery on a law enforcement officer, statute 784.031, third degree felony, be expunged or sealed if the charge is adjudicated withheld? And what exactly does adjudication withheld mean on a charge?
There is a long list. I don't remember batting on law enforcement. I don't know if that's encompassed in the general battery statute. But adjudication withhold means that the court has decided not to adjudicate guilt. But if it's on the list and you have a withhold, you still cannot get it sealed or expunged. And I believe battery on a law enforcement officer is an offense that cannot be sealed.
Okay. Next question related to sealing and expungement. If you have a felony conviction from a different state, can it be sealed or expunged in Florida if it's 34 years old and the person has no criminal conviction since?
Florida cannot seal the records of another state. It has to be an offense committed in the state of Florida.
Okay. All right. Well, we have lots of questions related to sealing and expungement. Does the law still prohibit you to seal or expunge if the offense you are found guilty of is a traffic violation? Is there a time frame where one could not request the traffic violation be filed with a holding?
I do not believe traffic infractions are on the list of offenses that cannot be sealed or expunged, even with a withhold. As I stated, there are so many. I just cannot remember them all. I put the major ones, and I don't think traffic offenses are included on that list.
I mean, so you can get a traffic offense sealed?
I believe so, yes.
Okay, next question. Will expunging records get rights restored to own a firearm? Probably
Well,
depends
expunging
on the offense.
Well, no, well, you know, you still have to disclose an expungement if you're trying to apply for a firearm, but I don't know how the recent legislation that doesn't require licensing permit is impacted by that. So I don't know the answer to that. That's a very good question. What I will say is that the state attorney's office will absolutely work with people who are trying to get their records sealed or expunged. If you send your application to the state attorney's office before you file it with FDLE, even if you're not seeking an expungement, as a courtesy, we will look through the application and let you know whether or not your offense qualifies or does not qualify.
Okay, and how would they contact you? Well,
They can contact me. That's fine. My information is on my slide.
yeah,
And
they would need to fill out the form, correct?
yes. And then if they were able to get that is it QVC code?
QR code, QR
code.
code, yeah.
If they were able to utilize that, the address of our office is on that form. They can mail us their application for review.
Okay. So the next question is related to that, and one of the attendees of the forum here said, I downloaded the forms but confused about which form it is. Order to expunge under section 943.0585. Do I send that to the attorney's office?
The order to expunge should come with the petition and the affidavit. So there should be 3 documents that accompany that go together. And yes, you send that to the state attorney's office for an expungement.
Okay. And we have a follow-up to a question earlier, just to confirm, is battery on an LEO, law enforcement officer? Battery on a law enforcement officer cannot be expunged or sealed? Sounded like.
I think the answer is no, but I'd have to look to see if a battery on law enforcement officer is included in the assault statute that's listed under the under that chapter.
Okay. All right. So that is all the questions related to sealing and expungement. So we'll let you finish up with some information on Marcy's Law. Camilla?
Really quickly, Dane,
Yes, ma'am.
just to address Kamila's earlier question about getting your disposition certified. Again, that's a public records request that you can actually secure in room 150 here at the Orange County Courthouse, and/or go through some of the other procedural steps that I listed to have a document certified and copied and shared with you, which is technically a court record and lists your disposition. In order to have something certified, there is a $3.50 charge associated with it.
Thank you, Roberta.
You're welcome.
Okay. Camilla, you
Okay,
wanna
so
get-
Marcy's
go ahead.
Law. Marcy's Law is a fairly new concept in Florida. It's a namesake of Marcy Nichols, who was a student at the University of California, Santa Barbara. She was stalked and murdered by her ex-boyfriend, and her family was confronted in a grocery store by him a week after the murder. They did not know that he had been released, and they did not have any information regarding her case. So there was a law passed in California, and it became the strongest and most comprehensive constitutional victim rights law in the United States. And that law has spread throughout the country ever since. So in Florida in 2018, that issue was put on the ballot, and it was voted into the 2019 Florida Constitution. It's found in Article 1, Section 16B, and it says that victims of crime or their lawful representatives, including the next of kin of homicide victims, are entitled to the right to be informed, to be present, to be heard when relevant, and at all crucial stages of criminal proceedings, to the extent that these rights do not interfere with the constitutional rights of the accused. So the goal is to make sure that victims are not left out in the cold, and that they are given an opportunity to be heard by the people that are supposed to be really protecting their interests. The amendment also states that the victim has the right to prevent the disclosure of information or records that could be used to locate and harass the victim or the victim's family, or which could disclose confidential or privileged information of the victim. And that's going to be important later on when we talk about what this really means, practically speaking. The definition of a victim in the Constitution is a person who suffers a direct or threatened physical, psychological, or financial harm as a result of the commission or the attempted commission of a crime or delinquent act against whom the crime or delinquent act is committed. We use the general sense of the word victim, someone who's been harmed by an act of crime. The term victim does not include the accused, and that's important because sometimes the defendant can also claim to be a victim and want to assert the same rights. But if you are the accused and you are charged with a crime, then you're no longer able to be a victim. Their case law is very sparse with Marcy's law, and that was part of the issue with enforcing the law because it was very broad and didn't provide a lot of guidance in terms of how to apply the law across the board. And victims were kind of left feeling like their rights were not being protected when people didn't really know exactly how to enforce Marcy's law. One of the case law that came out after the law was passed is Butler versus State. And it said that the rights provided to victims and victim families under Article 1, Section 16 are not absolute, and they are subordinate to the rights of the accused when the rights involved are in conflict. And, you know, that case law pretty much, you know, discusses the rights of the defendant to face their accusers and how that is seemingly in conflict with the right of the victim to withhold information about their identities. So some of the case law that came after the law was trying to create some rules and some boundaries with which to apply the law. In Holmes v. State, which is a pre-Marcy's law case, it talked about the decision to withhold from an accused the current address and place of employment of a witness intrudes upon their constitutional rights. The trial court should assure that the record reflects the proper basis for making such a decision based upon founded concerns for the safety of the witness. This LT case versus the state of Florida that came out in 2022 is a pretty important case. It was probably the first one that came out that provided any substantive guidance on how Marcy's law was to be applied. And the court found that pursuant to Marcy's law, a crime victim has a legally cognizable interest in proceeding. However, the interest does not entitle the victim to a party of record status. So that means that the victim is not a party to the criminal case. So non-parties or interveners are routinely granted standing in a criminal setting for the limited purpose of asserting and protecting specific rights, but they are not afforded the right to file demands, notices, or make motions as though they were a party of record in a criminal case. And as you know, the only parties to criminal cases are the defendant and the state. So a victim can't come in and say, I want to make a motion. I object to what the prosecutor is doing. I want the court to hear me. Now, I will say that that has happened in several instances that I've been involved with where a victim has retained an attorney and they have been able to make motions to the court, primarily because the judiciary was not clear on when they were to enforce the right of the victim to be heard and to be informed. And everyone has just been trying to figure it out. Another case similar to that is Dean versus State that came out in 2022. The counsel stated that Ms. Tomlinson's interest in the case, the victim, is whether or not there's some enforcement principle to Marcy's law for her to have an ability to have her wishes followed by the state's. In that case, Ms. Tomlinson sought to override the state attorney's decision to make a plea offer. That she could not do. The court held that the state had the prosecutorial discretion to invoke the Prison Release Reoffender Act regarding the defendant over the victim's objection. So even though Marcy's law gives the victim the right to be heard, the right to be informed, it does not give the victim the right to make the final decision in any prosecution. That still stays with the prosecutor. So back to this provision about the right to prevent disclosure of information or records that could be used to locate or harass a victim. What does that really mean? Does that mean that I don't have to give my name, my address if I'm the victim, and I don't have to tell anybody where I live or any information about myself? That could violate some constitutional rights of the defendant to know who the accuser is. That could also violate some Florida statutes that require the disclosure of certain information under public records laws. So very recently, the Florida Supreme Court came out with an opinion on November 30th in the city of Tallahassee versus Florida Police Benevolent Association, and it quashed the decision of the First District Court and held that Article 1, Section 16B, Marcy's Law, does not give crime victims the constitutional right to withhold their names or identities from disclosure. And this is very important because there were many offices across the state, law enforcement agencies, state attorney's offices that were filing informations and redacting the victim's name. We were redacting information in discovery, which potentially could be in violation of the defendant's rights to confront their accuser. And there was just a lot of confusion across the board. So this really applies across the board to public records disclosure and to discovery, as well as any other situation in which Marcy's Law would apply. Specifically, the Supreme Court found that a victim's name, the victim's identity, is not protected. The court used the common definition of the word identity, which is to find the identity of a person, and locate, meaning to establish that he or she is in a certain place, to conclude that identify means to distinguish someone from other persons, and that locate means to determine a person's physical whereabouts. Additionally, the court found that information or records used to accomplish the task of identifying are not necessarily the same as those that could be used to accomplish the task of locating or harassing another person. So the court said that one's name standing alone is not the kind of information or record that can be used to locate or harass victims. It communicates nothing about what individual can be found and bothered. So the court reasoned that the language of the amendment does not encompass a victim's identity, although it does provide for the confidentiality of any other information that could lead to the location of the victim. And lastly, because the locating the victim usually precedes harassing the victim, the court indicated that it did not need to discuss harassment separately in any detail. So that question is still open. The court also stated that shielding a victim's identity might raise other constitutional issues, including issues related to the accused's right to confront and the public right to review government records. And the decisions regarding the release or withholding of the victim's name should be based solely on existing exemptions codified in Florida statutes, and Marcy's Law should play no part in the analysis. So that means that the statutes that are already existing on the books of Marcy's Law, when it comes to releasing a victim's name, the opinion still requires the non-disclosure and redaction of any information that can be used to locate or harass a victim, such as an address, email address, a phone number, etc. So this is very important. While the Supreme Court case is very the guidance, it's not absolute. So based on this decision, the court declined to address other issues raised by the case, including whether law enforcement officers are entitled to certain law protections when acting in their official capacities. And that's what the case was about, that there were law enforcement officers who were involved in observable shootings, and they were shot, and as a result, they wanted to withhold their names from the release, from the media to protect their identity since they were victims of shooting. The case also not decide whether or not Marcy's Law requires a commencement of criminal proceeding before its provision takes place. And the court did not determine whether it must take affirmative action to exercise the right to prevent the release of protected information. It's not clear still whether or not the victim has to request to be protected, or whether or not the victim is going to be automatically protected under the statute. But from a practical standpoint, the decision provides very clear guidance for disclosing discovery or responding to public requests. Marcy's Law does not require the names or identities of victims in being held. And that is the final court opinion.
Okay, thank you, Camilla. So, yes, her audio started cutting out, so I just assume it's the connection that she has. But those last two slides. But we could see your slides at that point. So it was just probably your connection. So unfortunately, excuse me. Now let's get to one of the questions that we still had coming up here. We still have a couple questions that have come in. So the next question we have is, if the case that one wants to have expunged or sealed has been closed with a withholding, but the offender has a conviction of guilt for a driver's license suspension, can they apply for a seal, or does the traffic violation disqualify them?
You only get one bite at the apple, unfortunately. If you've had any record sealed or expunged in your lifetime, then that's all. That's all you get.
Okay, and then we're going to go to a couple of other questions here that came in so everybody can hear the answers on these. One of the other questions we received earlier was, how does one remove cases listed online that have been closed? For example, traffic citations. Roberta, you want to answer that for us? You did a written response, but let's share with everybody so they can hear.
Oh, okay. So you're gonna make me talk out loud. Again,
Sure, why not?
I did share with the customer. The public has access to all records of the judicial branch of government, except as provided pursuant to Rule 2.420, as shared earlier. Access to all electronic and other court records is governed by the standards for access to electronic court records and the access security matrix, both authorized by the Florida Supreme Court pursuant to an administrative order. And I provided that administrative order. Unless your case is listed as a statutory exemption under the court rule referenced above, and or by court order, it is subject to disclosure.
Okay, and then one other final question. So if anybody else on our webinar has a question, type it in real quick because we're down to our last question here. Will expunging a record get rights restored to own a firearm? So this was a question we received earlier. Roberta, you had an answer to this.
Unfortunately, no. The restoration of gun rights is considered a pardon, and it is an act of clemency. And so you must submit an application to the clemency department to restore your gun rights. Just because your case is sealed and or expunged, it does not provide you all of the other civil rights that have been removed as a result of the conviction.
Okay, thank you. All right, looks like we don't have any other questions at this point. So we're getting close to the end, but please, if you're on with us right now, don't go yet, because we have a survey that's going to pop up once we sign off. And we ask you to please take that survey. It gives us feedback on how we did for this presentation, topics you might want to see in the future, and any questions that didn't get answered. So again, anybody also looking for a recording of this, it will be on our Facebook page for the Orange County Clerk of Courts Facebook page immediately. We'll also have it on our website on myorangeclerk.com. So Orange County Clerk of Courts Tiffany Moore Russell understands the importance of these conversations in our community. It's why we provide these free legal forums to the community as one of Clerk Russell's top priorities. And we hope the topics discussed here were helpful to you all. And we want to give a big thank you to all of our panelists for joining us. Thank you for taking time out of your evening to share this information with the public as a service to our community. And we hope, again, this information was very useful to you. So once posted, you'll be able to view that on our social media platforms. And also make sure to follow the Orange County Clerk of Courts, State Attorney's Office, Orange County Comptroller's Office on our social media pages for all the latest updates. So thank you for joining us. As mentioned at the beginning, you'll see a short survey appear on your screen. Please fill that out for us. Thank you and have a great evening. Thank you, everybody.